Hi, and welcome to this Friday's edition of the Special Education News Roundup, brought to you by myself, Jennifer Price, Principal Attorney at the Law Office of Jennifer O. Price. This week, I'm talking about Title II violations, meaning Title II of the Americans with Disabilities Act, otherwise known as the ADA. Okay, the case this week is a sad case with sad results, unfortunately. There was a child who had cerebral palsy and autism. He was nonverbal and was fed through a gastrostomy tube in his stomach. Now, this child is going to be called KC. Now, KC attended a public elementary school in Kentucky, and while in the third grade, he was placed in what's called a functional mental disability classroom, taught by a special education teacher. Now, the special education teacher also had 3 other aides. One day, a child came home who shared a class with KC, crying to her parents, crying that KC was being mistreated according to her. She told them that KC was in timeout for long periods of time in the day, and the teacher yelled in his face and was also rough with him. So Casey's parents subsequently met with one of the aides in the classroom at some local restaurant in the area who confided in them that she actually did witness the teacher pull Casey's hair, scream in his face, and place him in timeouts for hours at a time. The abuse was so bad, according to her, that she was crying herself to sleep at night. She just didn't know what to do. So Casey's parents immediately contacted the sheriff's office, where they conducted an investigation. During the investigation, 2 of the aides were interviewed about what happened. So one denied the abuse. The second is the one who met with the parents. She repeated the allegations to the deputy, but the deputy said that she seemed a little non-committal about what she actually witnessed. Now, the special education teacher herself was also interviewed, and as you would expect, she denied the allegations. So in the end, no charges were filed against the teacher. The parents removed KC from the school, promptly filed a federal lawsuit. And as if the story couldn't get any more heartbreaking, the federal court dismissed the case because of a legal term called notice. Now, what do I mean by that? Well, in order to sue a school district for violating Title II of the ADA, you have to prove a few things, right? So first, you have to prove that the district receives federal funding. Well, this was done. It's a public school. Most, if not all, public schools receive some kind of federal funding. Second, you must show that your child is a child with a disability. Again, this is done. KC has both cerebral palsy and autism. Next, you must show that the child was denied the benefits of some sort of federally funded program or activity. Then last, if you want damages, you have to show deliberate indifference. Deliberate indifference is a legal term of art, and it basically says that the discrimination that was applied to KC in this case was intentional. And one thing that you must show as a starting point for intentional discrimination is knowledge or notice, as I mentioned earlier. Now, the problem in this case was that allegations were being made of a teacher abusing KC, but no one informed the principal, no one informed the superintendent, and no one informed the school board. The parents just immediately called the law enforcement. And while that is good on the one hand, because it can start a criminal investigation, in order to hold a school district civilly liable, one of the arguments being made is that the school officials, like the principal, like the superintendent, were unaware of the discriminating acts and did nothing to, or were aware and did nothing to address it. But unfortunately, in this case, no one had knowledge of what was going on, so the school couldn't be held liable. There was just no evidence or any other indication that even the board had knowledge of any of the complaints about the special education teacher. Therefore, other prior complaints to the board would have at least given the board notice and knowledge that this teacher posed a risk to KC and other children. So where do you go from here? Well, it's a tough case because if the parents had told school officials, then the school could have done an investigation on their own. But at the same time, the parents would have been placing KC at risk of the teacher continuing to behave in this way just to do that. That's why this case is so unfortunate. Without being able to prove knowledge, a parent can't make the argument that the school knew about something and did nothing on their part to address the problem. And that is a deliberate indifference claim, that the school was indifferent to the concerns being raised, and their indifference was deliberate because they were well aware of the concerns or injuries. That's all for this week. Have a great weekend.